Your Honor, good morning.
Good morning.
I understand that you sat on a grand jury indictment initiated by Mr. Guyot. That grand jury indictment came 3 days before a scheduled evidentiary hearing. I'm here to inform the court, ma'am, that Mr. Guyot and Mr. Minatoya are guilty of prosecutorial misconduct.
Okay, Mr. Pinkerton, hold on. What we have on calendar today, and the only matter on calendar today, is a motion for mental examination of yourself, filed by the prosecutor's office. So my question to you, and the only question you should be answering is, are you objecting to this motion? And I suggest that you speak through your attorney. Any statements that you make in this court can be used against you.
Your Honor, like I said, I'm trying to inform the court that serious violations on behalf of the prosecution.
Mr. Pinkerton, if you believe that you have a basis for prosecutorial misconduct or misconduct by law enforcement, then there is an avenue for you to address that. Was on the motion of the prosecutor. Is that correct?
That is correct.
Ms. View, the concern that this court has, it's unfortunate Mr. Guyot is not here today. I understand that the motion and order arose out of the district court. Ms. View? Okay. Now the problem I have is, for some reason, Mr. Guyot took it upon himself to inform Dr. Samsil that the court order that came out of the district court was flawed. And Mr. Guyot took it upon himself to limit the parameters of the doctor's report. And there seems to be some confusion with Dr. Samsil. Now, when this court reviewed the reports, and when this court reviewed the minutes of the last proceeding, it was quite clear from the court order that that there were two prongs to the examination of the three-panel. So I don't know why Mr. Guyot took it upon himself to inform the doctor to disregard the district court's order and to limit his examination and report. To Dr. Samsil's credit, he did raise that with this court. And this court did make contact with Mr. Samsil, and as correctly noted by Mr. Pinkerton, Dr. Samsil has been ordered to comply with the court order. But Ms. View, what I would like you to do is inform Mr. DeCosta and Mr. Guyot that in the future it is not within the purview of the prosecutors to draw limitations on a judge's order.
Matter and whether Mr. Guyot would admit that he delayed the proceedings by asking the doctor not to proceed on volitional capacity.
Well, are you disputing that he told the doctor only do the fitness to proceed? Are you disputing that?
I think there is a statement by Mr. Guyot.
That's a pretty simple question.
I know, but these are all matters that did not involve me personally. There is a statement in the memorandum in opposition I read a statement that the state had inadvertently asked for something in addition, but I don't see it in the...
The question of the court is the state disputing that Deputy Prosecuting Attorney Guyot told Dr. Samsil, you only have to do the report on the issue of the fitness to proceed? Are you disputing that? I'm not asking about delay. I'm asking whether you're disputing that statement.
I have no personal knowledge of what Mr. Guyot told the doctor.
I don't, so what is that?
And
Yes,
for the
no?
record, I would have to dispute it and give him a chance to respond to that.
Okay. But you're not prepared to respond other than the filing?
No, my marching orders were to stand on the motion as memorandum. of
Okay,
file.
this is what the court's going to do. The court has received the defendant's motion to dismiss. The court has received the state's memorandum in opposition. The state has indicated through its deputy prosecuting attorney, Mr. Meridian, that his marching instructions were to come to court today and stand on that memorandum in opposition. Based on that, the court will take as complete and final opposition to Mr. Pinkerton's motion, the state's memorandum in opposition. Based on that, the court's going to issue some findings and conclusions, which are going to include the fact that the state has not met its burden given its opposition filed in writing, and the state's going to grant Mr. Pinkerton's motion to dismiss the matter. And the state's going to grant it with prejudice. And I will say for the record that while I shouldn't speculate, but if I were to speculate, I would speculate that if there was a vigorous opposition to the motion with actual specific dates and times in which the state could meet its burden, that the motion might not be granted, but since that's not the court's job and it's the state's job, the motion to dismiss will be granted, the dismissal will be with prejudice. Mr. Hempy, I would like you to draft some proposed findings of fact and conclusions of law on, remember, the court's basing this on burden of proof and the state's failure to meet its burden of proof in opposing the defendant's motion to dismiss. I would like that drafted appropriately. You may forward a copy of the proposed findings of fact and conclusions of law and decision and order to the state. If the state wants to submit any proposed findings and conclusions, it may do so. I would like any such proposed findings and conclusions submitted to the court within, how's about 2 weeks from today's date? Is that acceptable? So we'll have them submitted by no later than close of business on Wednesday, August 15, 2007. So that being the case, I don't believe it's necessary for me to schedule another court appearance date for Mr. Pinkerton, because I would assume what's going to happen is I'll get the documents in and then I'll finalize the order.